Tuesday, they also heard a case around at what point an individual attempting to enter the United States can claim asylum protections. Joining us to discuss this is the Center Square Apprentice reporter, Andrew Rice. Andrew, thanks for taking time with us. It's a deep issue impacting a fair amount of people in the country, and there's also a lot of politics involved here. Give us an overview of what this case means and what justices heard today in court.
Right. Well, thanks for having me, Greg. This case is a hugely consequential one, as you said. Asylum is a big issue going on, and how it is processed in the United States is a big issue that's going on. Just getting out of the arguments earlier, reporting on those arguments, there was clearly a partisan and political divide. A lot of justices, some of the justices appointed, more liberal justices, clearly were wanting to side with this immigration advocacy organization that was arguing that if you are on the Mexico side of the U.S.-Mexico border, you should be entitled asylum protections. Really, it got all to the heart of this 1990 Immigration and Nationality Act that says once you arrive in the United States, you are entitled to asylum protections, and you're entitled to a hearing with an immigration judge and going through that official process. And some of the liberal justices clearly agreed with that, or appeared to agree with that in the arguments today. But there was definitely some pushback from the other side of the aisle, and a lot of justices were looking to define at what point does arrives mean. At one point, even Justice Gorsuch said, if I'm halfway across the Rio Grande, does that mean I've arrived in the United States? That was a really salient point that really showed how are we defining this term from a statute from decades ago, really. And it will have a dramatic impact on how we look at asylum law and truly just the definition of arrival in the United States moving forward.
Yeah, what exactly is asylum, and what words can people be told to use with border officials to be able to get asylum status? There's obviously a lot of nuance here, Andrew, but you were outside the courts when some demonstrators were on the steps sharing their perspective. Nicole Ramos, director of border rights at the Border Rights Project, she argued for it to be a humanitarian issue, one that takes a look at just exactly who is looking to get asylum and who would be cut off if the Supreme Court sides with those who want stricter asylum guidelines. Here's that clip.
We cannot be a people that says never again if we enforce policies that make death inevitable. We cannot be a country that espouses family values and to protect children when we let them die on our doorstep. We cannot be a country that professes to be one of laws and human rights if we allow a president and administrative policy to dictate who is desirable and who will be allowed in to grant access to the only legal process that can save their lives. Asylum is not a loophole. It is not a trick. It is the only legal process available for refugees to save their lives.
Again, an advocate on the steps of the Supreme Court just before the justices started hearing arguments, seeming to take a bit of a humanitarian approach to this. But you also had others who were sharing somewhat of a spiritual perspective. Here's Abi Janamanchi with the United Universalists Association. He's a reverend, and he shared his thoughts on how this idea is not just a one religion idea. Here's what he had to say.
People of faith and faithful people across traditions, Hindus, Christians, Jews, Muslims, and the occasional Unitarian Universalist as well. People who just know better, standing together. The brief that we all signed says what our traditions have always taught. Safeguarding and protecting the stranger is not an optional thing. It is at the heart of everything that calls us to practice radical hospitality, not just for individuals, but for whole societies.
Andrew, these are two perspectives. Were these brought to the court this morning? Were these things that they argued, or did we get more into kind of the nuance and the legalities of this question?
Right. That's a great question, Greg. Truly, in the arguments, there was not much talk about this idea of hospitality and needing to speak to a sense of faith and speaking to a sense of a, a desired goal based in religious tradition. Really, the justices and the lawyers representing both sides of this issue were focused on the legality of the issue. They were focused on what does it mean when someone is said to arrive in the United States? What does that definitional language mean? And the justices were really focused on that. There was not hardly a single appeal to the more emotional and humanitarian aspects that we saw in some of those clips. Really, it was a large focus on what does this definitionally mean? How did the statutes that have stated you are entitled to asylum protections when you arrive in the United States, how does that apply to the modern day when people are coming up to that US-Mexico border or any other port of entry in the country?
It's fascinating, again, to kind of see, on the streets, you hear about the humanitarian issues, you kind of have the tugging of the heartstrings, so to speak. But when it gets down to the nitty-gritty detail, it's about the legalese and how to interpret these laws. And in courts, a lot of the times, Andrew, I'm sure as you're seeing as reporting on the U.S. Supreme Court, they don't really, give lane to that emotional side of things. They seem to just stay in the lane of this is about the law, this is about our interpretation of the law, and we can't let emotion get involved in that. Andrew, what's next with this case, but also the case that we talked about to open the show with that you also reported on yesterday concerning election law? Give us kind of a timeline. When can we actually see some outcome of their opinions in these cases?
Yes, absolutely. Well, these are two very substantial cases, and it is kind of a surprise that the court is hearing them at this point in the term because the Supreme Court's term will wrap up at the end of June. Typically, they try to have all their opinions and decisions out by the very end of June so they can recess for July and August. However, there have been some exceptions in recent years when you have very substantial cases that reach into the very beginning of July. But the justices will have to make a decision on this case in the next few days, really. This case and the election law case that you mentioned earlier, these cases in the next few days, and start writing briefs and start applying the existing law and new law and have those decisions out by June. And I even heard this in the case today. Some justices really wanted that clarity on the arrival on what that arrival means because they know that lawsuits are going to come after they issue a decision in June at the end of their term.
Something else about the courts, it seems like some of these cases don't actually end at the Supreme Court. Sometimes it just opens avenue for other lawsuits in the lower courts, and we may actually see this or similar questions brought up in the future. But as we await a decision in those cases and plenty of others, Andrew, it seems that we do have a decision on a case that impacted the Center Square directly when it comes to requests for open meetings information. Tell us about this case.
Right. Yes, exactly, Greg. This case affected in a big way affected the Center Square. The Center Square has been litigating this case over the past several years over and allowing public and press access to meetings of the Tennessee Judicial Advisory Commission. They apply practices and procedures. They give recommendations to the Tennessee Supreme Court. And so we filed this lawsuit because back in 2018, the commission they sought to stop these meetings from being public due to a disruption. And so the Center Square filed a lawsuit, and ultimately the meetings have remained closed throughout litigation, throughout years of litigation. However, once the Center Square applied petition up to the Supreme Court seeking a relief in this case, seeking to open up these meetings to the public that were, according to court documents and the record, open for 35 years prior to their closure in 2018. We petitioned to the Supreme Court, but were unfortunately denied on Monday. We're denied, and that's going to be something that we're looking for kind of a closure to
some kind of resolution, right? Yeah, it's one of those things where as reporters we have to use public records laws sometimes to get information, and sometimes there are roadblocks. And when there are roadblocks, take it to court to see what the legalities really boil down to. Well, Andrew, greatly appreciate your reporting. We'll definitely keep an eye on what's going on at the U.S. Supreme Court, and you and the team with the Center Square are on top of that. Greatly appreciate it.